Good afternoon, everyone. The return of Live at 5 with Tim Panic Law. I kind of took the summer off after the extent of Karen Reed and everything like that, and spending time with my wife and daughter because it is a lot. But it's time to lock back in because it's a new season, and we're going to be talking about a lot of different trials. Like that Karen Reed was about 18 months that took up time. And this is going to be much more of I don't think we're going to have as major of trials, but we're going to have a lot of them. I think the first thing we're going to discuss is a recap of the Donna Adelson trial. Um, I so this being a Florida case, I'm familiar with it, and I never really got too much into it because simply I saw the evidence that was presented, and I was like, well, there's not really anything there that would be anything less than a conviction. It was a pretty straightforward case. There wasn't some conspiracy. There was no cover up. Donna Adelson did exactly what the prosecution stated that she did. It's not that difficult. It really wasn't. I was glad that the victim's family was able to get justice in that case because seeing her reaction after the verdict, like, like you know what you did. It's like you know the evidence presented. Like there was a few things like this isn't one of those. It was not a shocking end to the trial. You were charged with first degree murder. The state has to get an indictment, and they have to get 12 people to agree in the state of Florida to get a conviction. It's not like what was it? It's not like any other case. Even a second degree murder case only needs 6 people. So to get first degree murder, you got to get an indictment, which is the only thing in the state of Florida you need to get an indictment for, and you need to get 12 people to agree, which in other states is common practice, but here in Florida you only need 6. So, and based on how quickly they were out for, um, given that it was late afternoon, they're like, I don't even need to come back tomorrow. I know what my verdict is going to be that quickly. Um, yeah, with the verdict that quickly, yeah, they knew what they were going to do before they even went in there. But they're like, we got to do the process, we got to walk through the evidence, and we got to come to a just verdict based on it. Yes, with all that sobbing, no tears. Yeah, it was all an act. It was all a joke. And people were like texting me, like, Matt, it's like I am glued to my TV over this. And I was like, yeah, hate to spoil it for you, but Donna Adelson is guilty as sin. There's not really, it's like this crazy, intricate web. No, it's just a lady who should have just stayed out of her kids' lives. It's that simple. It's nothing earth shattering. It's nothing that it's like, oh my God, like, what about the prosecution presenting this? I was like, no, they got her son earlier, previously. They got her, Donna Adelson. And my expectation is, I think they're going to go after Wendi as well. I think that's what's going to happen ultimately because I think I saw something it was on the Surviving the Survivors podcast or something where it was the victim's attorney stated that the day he died was the deadline they gave to settle the divorce. So it's like, wow, that's really, really suspect timing. And when you practice criminal law, you can't really, you don't have the luxury of believing in coincidences. So I think that ultimately they're going to indict Wendi Adelson as well. Um, I think that they're probably going to do it sooner rather than later because she could get to a non-extradition treaty country before the indictment come down, and she could just stay there because her her whole family is destroyed. Her brother's in prison. Well, yeah, for the remainder of his life. Her mom is in prison for the remainder of her life. It's not like they have like, oh yeah, there's a PSI. It's a first degree murder. It's automatic life. I don't even know how like we even got to a PSI. Um, that's not how it. I was just expecting them to do the life in prison on the spot because that's what it is. First degree murder, automatic life without parole. There's the reason you say that there's parole doesn't exist in Florida, so it's just life. And when it's life, it's just without parole because that doesn't exist. I thought the prosecution did a good job. I thought the defense was wild. At times maybe trying to set up her ineffective assistance, a counsel defense, maybe. But I wasn't overly impressed by them. But at the same time, what did they have a lot to work with? Not that much. It was pretty straightforward what the evidence was, and there was not really a defense. And so here's like a tip when you're doing criminal law, when you're watching a trial. If you can't figure out what the defense is, that means there isn't one, and or there's no good one. Um, so yeah, that's pretty much where I see the Adelson case going. I think Wendi will ultimately be indicted for first degree murder as well. Um, it's if we were to quote Alec Baldwin in The Departed, "Cui bono, who benefits?" Out of everybody, she benefited the most with this. So they're not going to charge Charlie Adelson, try and convict Charlie and Donna, but not Wendi. It's not happening. Um, she'll ultimately be indicted for first degree murder. And I think she'll receive the same sentence as her whole family because just utter stupidity. Just get a divorce. I think I've said this before on previous podcasts. Just get a divorce. Don't be involved in this web of conspiracy involving hitmen and stuff like that. Just don't do that. Like really, like this isn't the movies. Those people don't figure out a way to get away with it. Those who do, that's Hollywood. There's no getting away with this for Wendi Adelson. Her day will come. So that's about Adelson, but about Fraser Bohm. So you got to hand it to Alan Jackson. Um, when I saw they were doing a motion for bond reduction, I'm like, he doesn't look like he's in custody. Am I missing something? So to give you an idea of what you do when you do a motion for bond reduction, usually the client is in custody and you want to get them a reasonable bond to be able to get out. That's what it's for. Say it was like I think he was originally set at what, $8 million, and then they lowered it to $4 million. So if it was he's in custody on a no bond hold, that would be a motion to reinstate bond or motion for bond reduction. More likely when the bond is too high that the defendant cannot bond out, and it's deemed an unreasonable bond. $4 million for 4 homicides seems reasonable to me. The fact that the defendant is actually out of custody is nothing short of very lucky for him. I can tell you that here in Florida, you get 4 vehicular homicides, 4 second-degree murder charges. You're not getting a bond. You're not. So thankfully, it looks like the judge saw through the argument. It's like, oh, what do you need this money for? It's like, oh, to hire experts. Yeah, that's not how this works. And the judge was correct in saying, it's like, my judge, when you were doing a bond reduction, it's an unreasonable bond and precludes the individual. It's an Eighth Amendment violation. That's what this is intended for. Not for you to lower the bond so that you can get a refund from the bondsman to pay experts and the attorney. As we know, Alan Jackson was paid, like the defense was $5 million and whatever his portion of it for the Karen Reed case. So you got to think it's something probably more based on that. So it'll be actually interesting to see if he stays on the case, because if he was banking on getting a bond reduction on the case, then he can make the argument. It's like, well, if you're not paying me, I got to move on to other things. I can't take this case pro bono. I actually just had somebody call me trying to get me to take a pro bono criminal case, and they have public defenders and Office of Regional Counsel. They would do that for free. Something like the individual stated, not something I would do for free. So on a second degree murder case, I don't anticipate Alan Jackson doing this for free. So then it begs the question, are they not going to be able to afford an expert, or did the defendant's family just send Alan Jackson to try to see, hey, it can't hurt. Let's see if we could save some money. So instead of paying an extra 200 grand for experts, see if they make it from 4 million to 100,000. and then our bond would only be 100 grand, so that we could get a $300,000 um, refund from the bail bondsman. It's just it was a ridiculous argument, and maybe it falls under the hey, it can't hurt to ask. But the judge correctly um, swatted Alan Jackson back, basically saying it's like that's not what this is for. This is not what a motion for a bond reduction is, so that you can get money back, so that you can pay for the defense. No, it deals with the defendant being held in an unreasonable bond. Since he's in jail, and since he's out of jail, it means he was able to bond out, so it's not unreasonable, and he's lucky he even got one. So. I ultimately think that this is not going to be as good of a case for Alan Jackson. So at best, it's what if you believe what they're saying is that the defendant was the subject of a road rage incident. Okay, so he's speeding. So maybe you can take away the mens rea, the criminal intent, but a jury's not going to be like, oh, that seems reasonable, and him killing 4 people with his car. Yeah, we're going to excuse it. No, that's not going to happen. Maybe it'll take the case and make it a manslaughter. Maybe more appropriate. Maybe more something. But a jury's not going to go from second-degree murder because of a road rage incident that nobody can stipulate, like corroborate, to yeah, we should definitely let this person off. Like that's excusable. That's not how criminal law works. It's not. Um, and definitely after seeing Karen Reed trial, you can expect the prosecution is not going to um, know exactly what the trial, like the jury selection basis is. Finding people who are sympathetic with the defendant, probably highly affluent with kids who have troubled backgrounds. That's the type of jury profile you're looking for. You need somebody to be like, I had a similar thing. I have a lot of money, and my kid has been a pain in my ass because I gave him everything and he did drugs and stuff like that. And that's on me. That's what they're going to be looking for. The prosecution will be like, no, I want people who are all middle class people who are like, this kid is a rich kid whose mommy and daddy gave him everything, including a car that he was absolutely shouldn't have been driving, and that it was too powerful for him. And at best, he lost control and killed four innocent people. It's just, it's not going to go the same. I was actually kind of shocked he took this case because it didn't have the same facts. Like, unless they're like giving him a lot of money, which more the power to him, and I would completely understand. But without it, I don't really see the lure in the case, because I don't think it's as strong as a defensible case. I think that you may be able to get it from murder to manslaughter, but with 4 dead kids, 4 dead college sorority girls, innocent people, a jury is not just going to be like, well, that's not my job to figure out who actually did this. I don't know if it was, he's going to believe that. And it's certainly not where this allegedly occurred. And people are well aware in the area about that particular road and how many fatalities there are. So Fraser Bohm that's not a particularly great case for the defense, but everybody gets a defense. Everybody's innocent until proven guilty. See what the fact says. They might try the same black box is wrong, like same thing that we've heard all along. But like I said, I don't think that's an overly smart case, an overly good case for the defense. I think I saw that there's a death. Kathy Rusin posted a death penalty case in Florida, so we'll be covering that. What's on, like, as it works its way through. This is important. Death penalty has gotten objectively more difficult to be able to get nationwide. But there are exceptions. Killing of a young child. No matter what a jury thinks, you kill a young kid, jury has zero bleeping sympathy for you. They will vote to have you executed, and they won't give it a second thought. That's how it is. And so it's kind of what you have here. The allegation is the defendant killed his 8-month pregnant mistress. So it's pretty clear what the motive is. You're pregnant and you are my mistress, so I can't have my wife find out about you. And so the motive's right there. And you're thinking to the jury, it's like, not only did you kill an innocent woman, but you also killed your unborn child. So bleep you, for lack of a better term. So, and also, it doesn't need to be unanimous in Florida. It doesn't need to be 12. But if the case is as strong as I've reviewed some of the facts with it, yeah, it's not going to be that difficult for a jury to get to 12-0. There might be one idiot on, like, in the Nicholas Cruz trial that, for whatever reason, votes to spare this guy his life. But with an unborn child, so if you're the prosecution, again, jury selection, what you're looking for: religious people, pro death penalty, and people who are pro life. And the reason is that you want them to basically be like, what, we're not getting into a kind of a philosophical discussion about abortion, but you want jury members who are going to be thinking, it's like, instead of, you did this and then you ended 2 lives, 8 month, that's pretty close to, if not viable, like, could have lived outside the womb, but you ended all of that. So it's definitely a situation where you want that kind of jury. And I ultimately don't think the jury's going to have a hard time getting to a death penalty verdict, the imposition of such, just simply because the facts are just heinous and the conduct is egregious, that this is kind of what we have the death penalty for, that some people don't deserve the right to spend the remainder of their life in prison, that some people's actions are so egregious that the law requires the ultimate the ultimate imposition of punishment. So I think that's where it's at on this. So a couple of announcements of what's going forward. We're going to be doing mostly Mondays and Tuesdays, but also Thursday is going to be the other day for Live at 5 at Tympanic Law. Same kind of format, major trials. Sometimes I'll chime in for a lunchtime one if we have a big case that needs it. Like, not really Karen Reed, but something maybe a little above it, because that's like top in a tier of itself for criminal cases. Courtney Clement, the OnlyFans model, I think we will definitely be covering, because that is in Miami and that's going to be a major murder case. I want to say that's going in the next 6 months or something like that. So we'll definitely be covering that. Anything in Massachusetts, anything in Florida, we'll be covering always, and talking about the analysis. So now we're going to come to the kind of the announcements of new stuff that's coming. One thing I'm going to be doing is I'm going to take the recording and I'm going to put it on podcast, so you can get it on like Spotify and stuff like that. So people don't have to watch it on this, that they can listen to it. So that's one of the things we're doing. I'm going to be starting a newsletter. It's actually kind of clever, the name. It's going to be called Hearsay Weekly. So it's going to come out every Friday, and it's going to be talking about the cases we're covering, laws, announcements, and kind of like analysis. Give you stuff, because what I don't want is, if you're reading something, I don't want it to be reading something that you can read 5 other places. It's going to be analysis and arguments that you're not going to find somewhere else, because otherwise that's a waste of my time and it's a waste of your time as well. If you can just find it from 5 other people saying the same thing. So it's going to come out on Fridays, and like, kind of sign up for it in a subscription. I'll have more about that in the coming weeks. And what I'm going to have as well is I'm going to be adding a subscription based to my law practice. So I have a lot of cases, but there's also a lot of people who have just simple questions that sometimes, like, you don't need a full attorney for this. Like, hey, what should I do? And I'm going to give, like, say 10, 15 minutes of my time. And with a monthly subscription, you can get, like, sign up for time with me and I can be able to answer questions. And like, okay, what kind of attorney? Point you in the right direction of finding an attorney, so you can be able to good one, like someone I've vetted, somebody I know is good. Probably not going to be seeking a referral fee, especially if it's something like out of Massachusetts. But it's just about, if you're subscribing and I'm giving you time, I'm going to give you good time and I'm going to point you in the right direction. That's definitely what we're going to be doing. I'm toying with the idea. With the podcast, like kind of 6 episodes that may come, but that's where we're starting with those things because obviously my practice is blowing up. We just had a motion to suppress that was granted, so my client got pulled over, had a bunch of drugs in his car. It wasn't his car. It was somebody else, registered to somebody else. And the cops removed him out of the vehicle and started asking him questions. I posted about this on Twitter. I still refuse to call it X. About like 6 months ago, less than that. And I asked people what was wrong. And a lot of people were just like, the stop now. And someone got real close, was like, yeah, Miranda should have been run. Yes, that's the answer. And I was like, all the statements are out because you can't ask him incriminating questions. Like the judge during the hearing was like, when he was asked, my client was asked a question, did you sell cocaine? Yes. Oh no, it was, do you have cocaine in the vehicle? Answer, yes. You can't ask that question because that is meant to be an incriminating response. Excuse me. So if you're a law enforcement officer, you can't ask that question and not having had Miranda because somebody needs to be informed of their right to remain silent. Because if they know that their statement is going to be used against you, then they may not answer their questions. And that's what's guaranteed under it. So the cops literally asked him all these incriminating questions. He incriminated himself. Then they put him back in the back of his squad car. He taps on the window, makes more confessions, and they use that to build a case against him. Motion to suppress, I filed. All the statements are out. Everything he said. It's just going to be at trial. It's a constructive possession case now, and a weak one at that. So state was originally offering 15 years, and they'd be lucky now if I take time served and probation. That's if my client's like, I don't want to roll the dice because the vehicle's not his. Um, and so sometimes what I'm going to be doing is I'm going to do also some kind of mock jury stuff. So I'm going to take some of my cases. Obviously, I'm redacting the names and everything, and maybe try them out on like nothing that's not public record. Like obviously, I'm not going to give statements of what my client has said to me. That would be a violation of attorney-client privilege. But stuff that's available to the public, and have a jury be like, and have you guys be the jury. So that's also going to be part of the live at 5 going forward. If I got like a major trial coming up and it's like, all right, I'm going to tell you the facts. You tell me what you actually think about the case and how it's going to play and like what is mattering to you, because that's the beauty about like being able to find out what a jury is, because until the jury's in the box and they're deliberating, you don't know. You never know what his jury's going to do, but you can get an idea with mock jurors what they would see as important. So because what we think as attorneys and what jurors think is important isn't always the same thing. And that's really important. So that's kind of where we're going, the future of live at 5. So there's going to be a newsletter, the subscription to my practice to be able to get some of my pay, like some time to be able to just ask legal questions, because like you don't always need an attorney, because a lot of people, especially lower income people, they could do some of the work themselves, but oftentimes attorneys were like, no, you need my help, and that's not always the case. And people are out thousands upon thousands of dollars for something that was like a 15-minute question, and they just printed out some documents online, and then they just did it themselves. So that's kind of what we're trying to do, because we got a lot of cases, definitely major trials coming up. And like I said, when I have a major trial, I'm going to use this stream to kind of have mock jurors. Obviously, if you're in the area that I'm trying the case, I'll tell you what county it is, and I'd just be asking that. It's like, yeah, you can't be a part of it, just simply because of you'd be predeceived to the facts and circumstances of the case. So if I'm like, I'm going to make up a fake county just to make it easy. Laurel County. If you live in Laurel County, which you don't because it doesn't exist, I would ask you not to obviously watch, just simply because you'd be predisposed to facts and circumstances of the case that normal people would not. But I think that's all. I actually got to go pick up my daughter now from daycare. I want to thank you all for joining in. So next stream will be on Thursday, unless there's a major something, and I'll let you guys know about it. And thank you all for joining me. And happy to be back with Live at 5 with Tympanic Law. Bye.